Hello, everyone. Thank you for joining us in our complimentary webinar series for the U.S. federal government contractors. We are coming to you live today from Washington, D.C. You probably found out about today's webinar through our newsletter, which reaches over 23,000 federal government contractors and service providers. Today's session is complimentary and also recorded. You can find the recording on our website and YouTube channel about 24 hours after the webinar. We have over 525 complimentary webinars on our YouTube channel. This includes all 52 parts of the FAR and all 52 parts of the DFAR and hundreds of webinars on strategic and tactical topics. If you would like to advertise in our newsletter or in any upcoming webinars, please email us at hello@jenniferschaus.com. A little bit about us. We are a specialized consulting firm focused on working with established federal contractors. We work with product, service, and software firms across the globe. For more information about our services, please visit our website and select About Us. As mentioned, today's webinar is covering the FAR supplements. It is complimentary and recorded. We began the series in January 2022, and you can find these past recordings on our website as well as future schedule with the registration links. As you can see here, we have covered several of the FAR supplements already, and we'll wind down the series on August 24th with the Veterans Administration. Then on Fridays, we cover the same agency or department in a playbook series. The Friday webinars discuss upcoming bidding opportunities, contracting trends, small business resources, and sometimes feature a government speaker. The full schedule and past recordings are on our website under the Playbook tab. Please join us at the Kennedy Center for a night of networking with over 200 federal contractors. Our quarterly event will take place on Monday, June 20th. Sponsorship opportunities are available. Federal agencies will be present and will be listed as they confirm. Please note that ticket prices increase on June 13th. We hope to see you there. And now we'd like to take a moment to thank our sponsors who help make the webinar series possible. We would like to thank the Virginia PTAC. The PTAC is based out of GMU in Fairfax and offers free one-on-one counseling to firms in Virginia on federal, state, and local procurement topics. Online resources and group training are free with no restriction on business location. If you are interested in learning more, please use the links provided to explore what PTACs can offer. And a special thanks to the Federal Business Council. The FBC creates and manages virtual and in-person meetings and events to connect appropriate industry and government thought leaders, product providers, and solutions with government programs that use them. The FBC works within mission-specific programs for a variety of agencies to connect government and industry in the form of in-person and virtual conferences, training events, policy dialogue, and outreach. Over the last 40+ years, FBC has become a comprehensive resource for connecting industry and federal government. Dastin is an IT and cloud solutions provider working with corporations, the military, and government agencies to lower their cost, increase scalability, improve operational efficiency, and meet compliance regulations using targeted cloud-based solutions. Dastin is a certified partner of Oracle NetSuite, a premier tier Google Cloud partner, and a certified partner of Cisco, Virtue, AO Docs, and Authenticate. For more information about Dastin services or to schedule a complimentary consultation, please email Joe Alston. His contact information is in the lower left corner of your slide, or you can also visit the Dastin website. Looking to connect with the government and military decision makers, GovWhitepaperscom is a free resource for the public sector and supporting industries to find, post, and promote government and military-related content. Stay informed on topics like Navy, Marine Corps, cybersecurity, COVID-19, AI, education, and more. Plus, upload your organization's content for free to boost your website traffic and exposure in government communities. Our B2G advertising options connect you with our targeted government and military audience, including premium content subscriptions that provide gated content promotion plus lead delivery directly to your inbox. Claim your free membership on GovWhitepaperscom today to get started. Thank you again to the attendees and our speaker for joining us today in our FAR supplement series. Today we are covering the FAR supplement on the Department of Energy. Our speaker is Devin Hewitt, and she represents the firm Procurement. As a reminder, we do not take questions, so if you have any questions for Devin, her contact information will be displayed at the end of the presentation and you can contact her directly. Thank you, Devin, for joining us today. I'll put myself on mute and wait for your cue for the next slide. The floor is yours.
Great. Thank you. Hello, everybody, and welcome to what I hope is a nice sunny day where you happen to be. I am happy to be here and thank Jennifer for asking me to weigh in here on the Department of Energy FAR supplement. I am a lawyer located in Northern Virginia at the firm of Procurement Law. I'm a senior partner there and head of the GovCon practice. I have been in this field, I hate to say it, almost 30 years and have represented companies as a partner in one of the top 25 law firms in the world and at a boutique firm and now this firm, and I represent a wide variety of clients in different industries here in the US and abroad. And I do happen to have a specialty in protests and in small business preference programs authorized and managed by SBA. Well, with respect, next slide, please. With respect to the Department of Energy, there are some interesting facts about the agency and acquisition that I wanted to just raise and discuss with everyone on the line here. 80% of DOE's annual procurement base is allocated to M&O contracts performed by management contractors. And they run the facilities that DOE has across the United States. In that capacity, these very large, generally speaking, large companies are sort of running the facility and then contract out on behalf of the Department of Energy with various contractors, vendors to help operate the facility. So really only 20% of DOE's contracting is sort of general contracting in the way that we know it generally for the government. In addition to that interesting fact, there are 2 senior procurement executives at DOE, and you'll find out why. There are 11 heads of contracting activities, 15 SBA Procurement Center representatives, 80 plus small business and M&O program managers, 22 contracting activities, and 36 different sites. So it's an extraordinarily large organization spread all across the United States doing a variety actually of very important work, but on the other hand is somewhat of a niche agency in terms of the focus and also in terms of general procurement matters. We are not going to focus on M&O contracting here. Instead, I'm going to focus on the general rules supplementing the FAR and that would apply to standard procurement matters. So I'm sorry if people who are there from M&Os, but they tend to be very, very large companies. Anyway, let's go to the next slide and learn a little bit more about DOE acquisition. The Department of Energy Acquisition Regulation Supplement, that's what it's called. That is a supplement to the FAR, which is the Federal Acquisition Regulation, FAR, and the Department of Energy supplement is known by the acronym DEAR, which is sort of funny, DEAR. If you've participated in any of these other sessions, you know that a supplement is what it says it is. It is a supplement to the FAR, which is quite extensive and covers general procurement in the civilian realm, including NASA. And it has sections from 2 to 52 on various areas or subject matters related to general government procurement. And what DOE has similarly are the same parts, subparts, and sections that relate to those of the FAR. except that in the case of these clauses or the numeration, the number that precedes the FAR sequence is 9. Every agency has different numbers. You're probably most familiar with the Department of Defense Federal Acquisition Supplement, the DFARS, and their prefix, if you will, is 2. So with regard to the DEER, Part 3 of the FAR is Part 903 of the DEER, which I have no idea if it's actually called that. I'll say the Department of Energy Acquisition Regulation. So the Department of Energy Acquisition Regulation is applicable to all acquisitions by the Department of Energy and something else known as the National Nuclear Security Administration, NNSA. And that's why there are 2 procurement executives, 1 for each of these organizations. However, there is an entire additional supplement in addition to the parts 1 through 52, known as Part 970, that is applicable only to M&O contracts, M&O contracting. And that's a fairly large supplement, and I will not be addressing the supplemental rules, terms, and conditions in Part 970. Now, a supplement means just that. There will be certain parts of the Department of Energy Acquisition Regulation which may not include any content because Department of Energy does not consider to have its own rules, regulations, or provisions affecting that FAR content. Most of the time, in many of the parts, what you will see if you look at the Department of Energy Acquisition Regulation is the name or role of a particular individual or role of the Department of Energy who has authority to act on the matters or sits in the role of the head of the contracting activity that is referred to in that FAR part, subpart, or provision. Now, there are some places in the Department of Energy Acquisition Regulation that have more substantive or substantial supplements to the FAR, and that is what I'm going to focus on. There are not many, so I don't think this presentation is going to go all that long compared to something like the DFARS, but I will focus on those things in the Department of Energy Acquisition Regulation that are really something new and different, or are something of a departure from the FAR, or a little nugget here and there that I see in the supplement to a certain FAR part or subpart that I think is interesting. But I'm not going to go over every single part or subpart because in some points, in some of those areas, the supplement is just merely one sentence referring or defining the head of the contracting activity, as I said. So next slide, please. What is interesting for this agency, it's true of some other agencies, but there is for the Department of Energy something called the Acquisition Guide. And it is called Procedural Guidance for the Acquisition Community. It is written primarily like the FAR for contracting officers or procurement personnel, but also like the FAR. It includes a number of provisions or substance addressing contractor rules, regulations, rights, entitlements, and responsibilities. It includes, by its own terms, what the guide calls internal standard operating procedures, as well as quote unquote best practices for the agency in conducting procurements and fulfilling their acquisition or its acquisition responsibilities. It is quite long. It's very user friendly. It's written in standard, colloquial language. So it's not as complicated as the FAR. It's actually far simpler, and it's fairly straightforward. And like the Department of Energy Acquisition Regulation, in some instances, it's more robust in explanations or addressing a more robust singular Department of Energy program, and sometimes it doesn't address anything that's in the FAR, or just does so briefly, again, like the FAR supplement, just naming a role or an individual that has authority to act on the duties or responsibilities reflected in the FAR part or subpart. Next slide, please. Well, with regards to who's running the show with respect to acquisitions and procurement, Congress delegates the contracting authority in the first instance to the Secretary of the Energy and DOE, and then the back of, or the Administrator and NSA. And then the Secretary of the Energy or the Administrator of the NNSA delegates it to the Senior Procurement Executive for each organization. And for the DOE, it's the Director of Office of Procurement and Assistance Management. And for NNSA, it is the Deputy Associate Administrator for Acquisition and Project Management. The Senior Procurement Executive for each organization in turn delegates the authority to each head of each contracting activity within the organization, and each head of the contracting activity appoints contracting officers for procurements within its contracting activity scope responsibilities. And as you may know, contracting officers have different delegations as to scope and, more importantly, as to amounts, dollar amounts of contracts for which they can negotiate and award. Aside from that, the DOE, like most agencies, has an Office of Small Disadvantaged Business Utilization. And as I referenced earlier, there are procurement representatives from the Small Business Administration within the agency throughout. So while they don't have direct authority to contract, as probably most of you are aware, they do participate in contracting activities, particularly advocating for small businesses and set-asides, on bundling and contract aggregation issues, and potential problems in the contracting realm uniquely affecting small businesses. So it has a fairly large one, and there are small business representatives that are supposed to be providing access to small businesses and answering questions regarding acquisitions. I will say that I think both on the DOE website and in the acquisition guide, there is an interesting statement which states that, or almost apologizes on behalf of DOE, that because of its M&O contracting system, and because 80% of its contracting dollars go to those contractors, that it doesn't have a whole lot of contracting opportunities for small business other than those that might occur under these M&O contracts. And they have somewhat of a different acquisition scheme. And of course, you are in fact contracting with these M&O contractors who are contracting on part of DOE. So there is really more of a subcontractor relationship, which, it doesn't give you the face time certainly, and doesn't give you the direct privity with the government that makes a prime contract more valuable to small businesses. So as I said, there is some recognition by the agency that because of the services and responsibilities it has to the taxpayer public, it is not situated in a way that it can offer the small business opportunities that other agencies can. So, put that in your cap and ruminate on that. Let's go to the next slide. Well, the first area that I saw that was a little bit interesting with regard to the DOE supplement is in Part 903, which is generally improper business practices and personal conflicts of interest, organizational conflicts of interest, responsibility matters, suspension and debarment. That's all in Part 3. Well, apparently DOE has something that it's called the DOE Contractor Employee Protection Program. And it is a special program that not all agencies have, at least I'm not aware that all have, in which it is designed primarily to protect employees of contractors who blow the whistle on those contractors. And so the real scope, as indicated here on the slide, is that this program is applicable to complaints by those contractor employees to say that their employer has retaliated because they have disclosed either information to DOE Congress regarding certain violation of laws, rules, or regulations by their employer, or fraud, mismanagement, waste, or abuse by their employer, or their refusal to engage in what they believe to be illegal or dangerous activities, which the employer requires them to do as part of their employment. So this again is to encourage contractor employees to come forward in the appropriate circumstances. And although under the laws themselves, contractors shouldn't retaliate, the DOE apparently has set up a separate program for this and provides some sort of cover, if you will, for anything that the contractor may do in response or in retaliation to information that is flowing from an employee to the agency or Congress. Next slide, please. Competition requirements. Another interesting nugget that I saw is that any work assignments made by DOE to a named subcontractor must be supported by what we generally call a J&A, but a justification for other than full and open competition. And I think this is somewhat interesting because a lot of contractors who are in a prime contract role often get requests, generally speaking, informal requests from the agency to support or contract with another company so the government can get to that company through the prime contractor. And, you know, generally as a courtesy or furthering good business relationships with the agency, prime contractors take on this request and do it. But DOE at least recognizes that this is certainly a way for an agency or an agency official to get around the competition mandates that are in the FAR and stem from the Competition and Contracting Act. And so in order for this to be done, there must be a justification, and the justification must show that the subcontractor's responsibilities are going to be coextensive and within the scope of responsibilities of the prime contract. So you can't, in theory anyway, have an IT contract, a prime IT contractor subcontract with a environmental remediation subcontractor just to find an avenue or a source for the DOE that can avoid some sort of competition or independent procurement. And of course, the directed subcontractor has to show that it can actually do the work that the agency needs done. There is the suggestion that perhaps a sole source contract to the subcontractor directly is a better way to go, other than going through the prime. And the obvious reasons for that is there's generally markup. When you're dealing with a prime, there's another level of communication and privity, certainly, with regard to contract responsibilities and entitlements. So there would be a Joe Falk either way, but I think in some ways contracting officers find it a lot easier to do this direction through a prime contract. Now, what I wonder in practice is whether, if you do an informal, request, whether that, whether anybody will really know that's a request that should be subject to this justification and approval process. I mean, does that really change the fact that there has been requests that are really informal and just mere suggestions. So I don't know how helpful this is, but it is included here and certainly not in the FAR. Next slide. Qualifications. There is another interesting nugget here regarding responsibility. As most government contractors know, that in addition to being a contract awardee and fulfilling all the requirements for a particular contract, an agency cannot award a contract to any contractor unless it first makes a determination that the contractor is quote unquote responsible. And that term has a unique definition in the context of government contracts. And in the FAR, there is a checklist of items indicating the various topics that a contracting officer will look at as appropriate in the context of an acquisition to determine whether a prospective contractor will be or is responsible. A significant part of that review has to do with financial capability. Technical capability will be looked at to the extent, for example, a contractor is going to do production or manufacturing, and there's a need to determine whether the facility itself is real and licensed or operating, although one would imagine that that would be part of the technical review. But when it comes down to it, financial wherewithal, also looking at the various reps and certs that a particular contractor may submit, whether it's suspended, debarred, et cetera, is all part of the responsibility review. This particular supplement includes a supplement that talks about the application of the various responsibility factors to a joint venture. And many joint ventures are created, generally speaking, in the commercial marketplace, and no differently in the government contracts industry, are created for a particular opportunity or set of opportunities. And it usually includes two companies or more than two companies coming together to go forward and collaborate on a venture, which is a commercial or government business opportunity. In government contracts world, particularly if you're a subcontractor, joint ventures are extremely common. And particularly if you are a contractor that participates in a mentor-protege program, joint ventures are often the reason companies enter into that program, because it allows large companies who are mentors to enter into joint ventures with their protege, which is generally small business, and have that joint venture be qualified for small business set-asides, which a large company in a typical joint venture wouldn't be able to do, because under the SBA rules, joint venture members or partners are considered affiliates of one another, and therefore SBA will aggregate the size, whether it's employees or revenues, of large venture or large company with the small business. And then if you do that, of course, you're no longer under the particular size applicable to a particular procurement. So mentor-protege joint ventures, or all small joint ventures, if a business is a small under the size standard, they can joint venture together without being affiliates. And then, of course, there are special rules for different flavors of small businesses, 8As, SDVOSBs, et cetera. So there has been an issue with these joint ventures, particularly in the small business realm, for quite some time about considering past performance. I imagine most people are familiar with the controversy over the years, because if a joint venture is created for an opportunity, it itself, even though it is a separate legal entity, which it is required to be under the SBA rules, it itself, even though it's really a shell entity, will not have past performance. So in order to be viable in most procurements, an agency has to consider the past performance of the members of the JV and not the entity itself. And there was until, well, I wouldn't say recently, but until recently, a couple of years ago, inconsistency among the agencies about whether they would consider the past performance of either member, both members, how they would consider the past performance, and how they would weigh the past performance. Subsequent to this controversy, SBA actually published a final rule which required agencies to consider the past performance of the participating members of small business joint venture. Unfortunately, there's still some inconsistency on whether that has to be done, how it's done, how it's weighted, but at least it's in the regulations now. With respect to DOE, this new nugget, if you will, has to do with looking at the responsibility of joint ventures, which is an issue that really hasn't come up. And if the DOE is going to award based on a newly created joint venture, this contracting officer will take into account the financial resources of each member, just like it would do the past performance. But here, the member who has the financial resources has to be connected for financial performance through contract. So legally bound by a guarantee or some other contractual document to support the joint venture in the event there are financial problems. Now, that specific guidance or guarantee is not required in a mentor-protege agreement or in joint ventures generally. Now, part of the assistance that a mentor often provides, certainly in construction contracts, are bonds and perhaps other types of guarantees, but not typically, for example, in a professional services contract. And perhaps in a financial services contract, financial guarantees or financial performance isn't a huge area, although it can be in a small business area. And indeed, the SBA has a separate program called the Certificate of Competency Program, which handles allegations of non-responsibility by contracting officers for small businesses based on the fact that there aren't adequate financial resources. So it's not clear how this particular responsibility review and requirement for a financial guarantee intersects or dovetails with a certificate of competency referral and review by SBA. And of course, as I say here on the slide, that if you are going to require a guarantee by a member who has the financial resources that one of the members lack, the guaranteeing entity must, of course, have those financial resources to satisfy the guarantee or the bond in this case. Next slide. Contracting by negotiation. Well, this is Part 19, and therefore a Department of Energy Acquisition Regulation Supplement 915. This is, again, another interesting nugget from my perspective. And before source selection starts or evaluation of proposals, the Department of Energy Acquisition Regulation actually has a regulation that states that a determination is required as to whether there exists sufficient DOE personnel with the quote-unquote necessary training and capabilities to do the actual evaluation, which I think is sort of funny that it's actually written as a requirement as to, as opposed to an assumption that the DOE or any agency would typically assign individuals with the necessary training and capabilities. Perhaps there's a history here that hadn't always been the case, so now it's a requirement. Now, it's not one that I think contractors are likely to seize upon, because most often contractors don't know who's on the source selection board or who are technical evaluators. But it is set forth here as explicit guidance for contracting activity in terms of setting up a team for evaluation. The regulation also says that non-federal employees can participate in the evaluation, and certainly for certain highly regulated technical work, like nuclear power plants or international banking or financial services, it's often common to include a contractor to participate that. But this SPAR supplement section makes clear that these non-federal personnel can only participate in the technical evaluation. So they're not supposed to be participating in any financial review or any cost realism or audit capacity. And they're not supposed to be source selection officials either. So again, an interesting tidbit. But the supplement does assure the contracting community that these non-federal evaluation personnel will sign non-disclosure agreements, and the contracting officer has to state in the solicitation, letting offerors know that non-federal personnel will be used to evaluate proposals. I imagine that that is a mechanism to further a mechanism of protest should, for some reason, the contracting community find this objectionable in a particular context. If you put it in the solicitation, an offeror always has the ability to object or protest a term of the solicitation. So this would just be another term that would be subject to protest if there are obviously good grounds for that in a particular context. Next slide. Similarly, the Department of Energy acquisition regulation specifies that contracting officials should use the weighted guideline system for doing a price or cost analysis of proposals. Now, this is referenced as an option in the FAR, but it is mandated in the Department of Energy acquisition regulation. And I will confess that this type of analysis is not one that I'm very familiar with, because it's a more nuts and bolts pricing or numbers approach, and I can't even balance my checkbook on a good day. So I'm not going to pretend that I know the nuances here. But I know that the actual regulation states that the DOE has adopted this because they consider it a structured approach for determining what would be the appropriate profit or fee in a particular context. And that the reason for this is to, quote unquote, properly reflect differences among contracts and circumstances relating to a particular procurement. So what might be appropriate in another contract with respect to profit and fee may not be in another context, and this weighted guidelines approach is a way to somewhat create a baseline against all those differences in each context. Notably, the guideline system is not applicable to M&O contracts. It's not applicable to construction contracts. It's not applicable to construction management contracts or supply contracts or termination settlements. So one would think that that would be a very good percentage of the contracting that DOE does, particularly since we already know that 80% of the contracting goes to M&O. So where the weighted guideline system actually applies is probably a very small subset of acquisitions. Next slide. Like the FAR, with respect to the weighted guideline system, the Department of Energy acquisition regulation lists all the topics or the elements that would be considered in this weighting guideline system. And the way I understand it is that depending on the context of an acquisition, there will be a particular weight that the DOE considers important and relevant to an acquisition, and it will use those various weights and apply it in evaluating profit or fee objectives. Can't say much more than that, but if you have people who do pricing or develop proposals and pricing or analysis. Presumably, they're more familiar with this than I am. Next slide. Small business programs. Well, there is a big supplement or departure here with respect to the Department of Energy. First of all, the Department of Energy Acquisition Guide has a large area, a good chapter addressing small business contracting, and it was updated extremely recently, last month. And 2 years ago, it published a small business first policy, presumably to address the earlier apology I talked about, where it understood and acknowledged that at the end of the day, the small business opportunities with DOE, at least directly, are very few and far between. So one mechanism that DOE has adopted to try to create incentives for the large contractors who do most of the work with DOE to take small business contractors under their wing is similar to the SBA's mentor protege programs. It used to be, of course, the SBA 8A program, mentor program, and then the all small for everything else, but now it's all small business programs. There are separate rules here for the DOE programs, and one major incentive that you don't have with the SBA programs. The program manager for the DOE's Mentor Protege program is the OSBU. The mentor must have been performing at least one contract for DOE before it applies to be a mentor, and the protege must have been in business for at least 2 years before applying to the program. The most important thing here is that the mentors are supposed to provide developmental assistance. Next slide, please. Now that's not too terribly different than a mentor would provide for any other protege in the other programs. They can provide management guidance, how to manage the company, other engineering and technical assistance. And in other contexts, we've seen things like helping companies get ISO qualifications or CMMC certifications and the like. The mentor can award non-competitive award of subcontracts. And if you think that reference is a bit odd, there is a general rule that prime contractors should compete their subcontracts to the maximum extent practicable. And so for that reason, you might see in a lot of teaming agreements with prime contractors that they will, target a certain work share, but subject to their requirement to compete subcontracts. But in the case of a mentor-protege relationship, there is no need, at least formally, to acknowledge that rule. Also, they may provide rent-free use of facilities or equipment leased by the mentor. That is not too unusual in a mentor-protege context. It is more problematic where you have a large business doing that with a small business, even if that's even a prime sub relationship. The mentor may actually temporarily assign mentor-protege to the protege for assistance. So there could be an employee sharing relationship, which is not something you commonly see in a standard mentor-protege agreement. Next slide. The main difference and the main incentive of entering into a DOE mentor-protege program, aside from the SBA programs, is that the cost that the DO mentor incurs to provide such assistance is actually allowable under their contracts, which is something DOD has provided well. That is not the case in the regular mentor-protege programs run by SBA. They can also earn award fees associated with their role as mentor, depending on the contract. Of course, they will receive credit under their subcontracting plans for subcontracts awarded their protege. The difference there is that those subcontracts don't necessarily need to be awarded under the same contract in which a subcontracting plan has been instituted. Now, I will say that that's not likely to be common because large contractors have the ability to have sort of a consolidated subcontracting plan that's administered across their contracts. So, that may not mean much. The mentors and proteges, however, are required to submit something called a lessons learned document following the end of the relationship. The SBA program requires mentors and proteges to provide certifications that everything was done according to the rules and regulations applicable to the SBA mentor protege program. But here it's a little bit more of a document that talks about the exact relationship and how it was conducted and proceeded along the duration of that relationship. And there is an accompanying DFARS contract clause that's included in all solicitations that are greater than the simplified acquisition threshold. So it's a fairly robust mentor protege program that indeed has teeth to it in a greater way than that conducted by the SBA program. Next slide. Patents, data, and copyrights. Under the standard FAR clauses, a contractor can elect to have title and seek ownership of subject inventions created under a particular government contracts. And the whole Part 27 of the FAR and the whole patent IP data rights policy is always to encourage commercialization of technology and inventions and IP created under government contracts. But with respect to the Department of Energy, they have a statement that they find patent rights actually a type of incentive that can directly lead to commercialization, which otherwise might not happen. So what that means is that with respect to the DOE, the regulation says DOE takes ownership of subject inventions, and then the contractor can petition to get ownership and file for patents on those inventions. So there's a little bit of a different burden here with patent rights. Now, where DOE does take title to inventions, the contractor will have a license to do it, but they're not exclusive and they're revocable, which is not, it's not something that the contractor may like and not what typically happens. And as I said, the contractor certainly can ask for permission, but that is a process in of itself. Next slide, please. So there are class justifications where DOE may waive these rights. In particular, again, this concept of incentive to achieving development and commercial utilization of inventions, they may waive the presumption that they will get title. Now, this is far stricter, obviously, for programs involving nuclear weapons or other highly classified programs. And even if the contractor does get the patent rights, DOE still receives license rights to use the invention. Next slide. I think we'll go into that a little bit more detail. So when you talk about rights and data, technical data, copyrights, once IP is created, the contractor has a right to use it for its private purposes. But in order to use it and place a copyright legend, it in certain instances has to ask for permission. Now that's true actually in the FAR as well. Now that doesn't mean that the contractor doesn't have IP rights or the right of copyright. All this talks about is asserting a copyright, and that means placing a copyright notice on IP, which advises the public that the IP is indeed copyrighted and owned by another entity. And while it's not required, a copyright notice does make it easier to enforce a copyright. So the DOE says that with respect to copyright of IP discussed or reflected in scientific and technical articles, you don't need to get explicit permission from DOE to assert a copyright to that article. That's also true of the FAR, actually. But if you're going to assert copyright in other types of data or computer software, you have to demonstrate that that copyright is going to lead to or enhance commercialization. And there's a formal application procedure. And with, unlike the FAR, DOE actually has to receive a copy of the data. And with computer software, they're talking about source code. And that is sometimes quite disagreeable to contractors because source code is the crown jewel or the heart of any computer software that has been developed. And for at least 5 years after DOE gives permission to assert copyright, the contractor has to provide DOE with a non-exclusive, irrevocable worldwide license to the data, which means they can do pretty much anything they want, but they can't distribute it to the data to the public or permit others to do so. So they're not going to give out source code to anybody, but they are going to use the data perhaps in procurement, use it on their other contracts. But in doing so with computer software, it will contain the copyright legend and the source code will not be distributed. And with respect to other IP, it will reflect the copyright legend, which again is notice to other vendors or contractors that this is not in the public realm and available for any type of use under the Copyright Act. Next slide. The last slide I think here has to do with novations, which is discussed in a little subpart of Part 942 or Part 42 of the FAR. Part 42 of the FAR discusses novations and change of name agreements and includes the novation agreement and the forms and sort of states the policy or the rule that is necessary under the Anti-Assignment Act, which generally prohibits contractors from giving contracts to other entities. The DOE acquisition guide actually has an extensive guide or extensive guidance regarding how an agency is going to accept and review novations, which other agencies don't know. I mean, often, particularly with even big agencies like GSA, you're sort of flying blind. You do what the FAR says, and there's a prescribed form, and then they have a list of documents that must be included in the novation package. But once you give it to the contracting officer, you really have no idea what happens to it, how long it's going to be reviewed, what the issues are going to be, and any interaction you might have with the agency regarding that package. But the good news here is that DOE does have guidance on actually the more standard operating procedures the agency used to consider those novation packages. So really is great for those companies looking to novate the contracts they have with DOE. So that's about it. I actually took a little longer than I anticipated, but you give a lawyer a mic and it's hard to turn them off. Thanks for your time. You've got my name and number. You know how to reach me if you have any more questions, and I hope I'll be able to respond to them. I hope you have a good afternoon.
Thank you so much, Devin. That was such a great presentation. Thank you to all who participated. The recording and slides will be available within about 24 hours or less, once again. And then please join us at the Kennedy Center for a night of networking with over 200 federal contractors. Our quarterly event will take place on Monday, June 20th. Sponsorship opportunities are available. Federal agencies will be present and will be listed as they confirm. Please note that ticket prices increase on June 13th. We hope to see you there. Thank you so much, everyone. That concludes our webinar.